Our next session deals primarily with a fundamental legal skill, and I think most of us have now encountered in our practice, even in the first few months of our practice, that we may have gotten little or even no instruction on when we're in law school. But I think that you probably will all discover over the next year or 2 years, I've certainly discovered in the first few years of practice, that having good legal drafting skills, working with contracts, interpreting contracts, negotiating contracts, is really fundamental to just about any particular practice area that you might encounter. Whether you're working in personal injury contexts or more traditional corporate transactional contexts, whether you're working with employment clients, or even with criminal clients. Having the skills to put your thoughts and your agreements to paper, having those contracts mean what they say so that they can hold the test of time is really something that's very important. We are so lucky and so fortunate to have with us this morning Seaman from Hunt & Williams. Mr. Seaman's practice focuses on global outsourcing and technology issues for Fortune 500 companies. He has handled major business transactions and deal work throughout the world, and has just recently reminded me that he fortunately doesn't have to travel internationally as much as he used to as a young lawyer. He's handled work in as far-reaching regions from Richmond, Virginia, as Pakistan and Warsaw, Poland. Mr. Seaman is a graduate of Williams College, where he majored in French. He's also a graduate of the University of Virginia Law School. He's a partner in the Global Outsourcing and Technology Group and the Commercial Practice Group at Hunt & Williams here in Richmond. We're so fortunate to have him this morning. Please join me in welcoming him.
Thank you very much. Thank you very much. I've got good news and bad news. The bad news is my colleague, client, former partner, Luana Poison, who was supposed to do half of the presentation, couldn't come today because she's got negotiations in Washington. Good news is you get out of here earlier. So, as was just stated, contract drafting is not just something that corporate lawyers do. It's something that really any lawyer does. Anytime you've got an agreement between two parties, whether it's a 200-page outsourcing agreement, a 15-page services agreement, or even a settlement agreement, a release, something that litigators do. It's a contract, and there, two sides of it needs to be binding, and so it has to be drafted carefully. The purpose of drafting, the purpose of the contract, it's an agreement between two parties, states their rights and obligations. It's a roadmap. It sort of tells a story about what the parties are going to do. You're going to paint my house, I'm going to pay you $100. Story. It also protects the parties. It gives a legal framework for their relationship. And that could be as simple as saying, this agreement is governed by the laws of the Commonwealth of Virginia. When you say that, it imports, as my contracts professor Saul Leffmore used to say, it imports all the off-the-rack rules, say the UCC, for instance. And it also tells, in the best of circumstances, it tells the parties what's going to happen if something goes wrong. If you fail to paint my house, I don't have to pay you, or I don't have to pay you as much. It could be whatever the remedies are that you want, but it tries to anticipate what happens when something goes wrong. And really, that's usually the only time that you have to pull out the contract, is if something goes wrong. That's why it needs to be so carefully drafted. Drafting versus writing. Many of the same rules apply. Everything that you learned in high school about writing applies to drafting contracts. The idea is it needs to be clear and it needs to be as precise as possible. Going back to the example I gave, you'll paint my house, I'll pay you $100. More precision gets brought into that by the lawyer if you're representing the client, the paintee. Say, okay, you're going to paint my house, right? Are you going to paint it a certain color? Are you going to paint it in multiple coats? Are you going to paint it with various different kinds of paint? How quickly are you going to paint it? All that sort of stuff helps make more precise the obligations of the service provider. On the other hand, the service provider and his lawyer is going to say, okay, you're going to pay me $100. Are you going to pay me all at once? You're going to pay me 25 bucks up front? What happens if I paid the house halfway through and lightning hits it? Do I get paid the rest of it even though I haven't painted? Do I get paid my profit? You get the idea. It's a lot of precision that you're going to bring as a lawyer to the agreement. Personal pet peeve. I do a lot of agreements for entities, XYZ code. A lot of times the clients will say, oh yeah, the party to this is XYZ. Was the party to this XYZ Inc., XYZ Incorporated, XYZ Common Inc., XYZ Co. Each corporation, each entity has an exact name that's on file in Virginia with the State Corporation Commission. So what you want to do when you're drafting an agreement is get the right entity, the exact name, comma or no comma, and then it's a Virginia corporation, a Virginia limited liability company. Because the State Corporation Commission is not going to allow there to be two XYZ Co., XYZ Inc. There. So it's important to have the exact name of your entity. Forms. You guys, anybody who's done any of this have probably worked from forms. That's a good thing. One of my partners that I worked for when I first started said, beware of your creative writing skills. Use prior art. A lot of times you'll have a provision that's been tested by litigation, tested in court. Everybody's looked at it, every which way, and it works. So if somebody has done it and it's a good provision, use it. On the other hand, don't just look at one form of agreement if you're doing a purchase of goods agreement. Look at a number of forms so you sort of get a perspective about different ways to describe different things. And it's sort of like you'll know it when you see it, but you can usually tell what's a good form and what's not a good form. By the same token, know the context of the form that you're using. Was it drafted by the buyer or one side or the other? Is it sort of a middle-of-the-road form that's the result of a lot of negotiations? Got to be careful with that because if you've got a form that's been heavily negotiated, particularly a huge document, you will have lots of provisions in there that have been fought over back and forth by the parties and might have come up with sort of a warped result that sort of works for them but wouldn't work in another situation. So beware of that. The other thing you should know is whether your form represents the market position. If it's too one-sided one way or the other, you're going to get into negotiations with the other side. And you can say, I've got to have this provision, I've got to have this provision. And then you find out that really it's not what most people agree to, and you're going to look like you know what you're doing. Read all the provisions carefully and think about them as you're reading it. Remember, you've got a specific set of business facts. You've got a form that you're using. You don't want to necessarily try to morph your facts into the form that you're using. The better thing is to adapt the form to your facts. And it's very tempting, particularly as a young lawyer, just to say, well, it must have worked last time, it's probably going to work this time. Maybe not. You need to think about what you're doing. If you don't know why a provision in an agreement and you can't figure it out after giving it some thought, ask somebody. Ask the partner that gave it to you or the senior associate or whatever. Because if you include a provision in an agreement and you don't know why it's there, invariably somebody's going to ask you, well, why is this in here? I don't understand. And you're going to sit there sort of saying, ugh. And the most embarrassing time for that to happen is when you're in negotiations with the other side, because usually it's you, your client, the lawyer, other lawyer, and his client, and when you sort of sit there and say, I don't know why this is in here, you're going to look like an idiot in front of your client. By the way, if anybody's got any questions, just ask them while we're going. I'm not insulted by being interrupted. Style. You'll see when after you've looked at a number of forms of agreement, each one has its own style. If it was drafted in a consistent manner in the first place, it should read similarly all through it. Some agreements are stated very, very plainly in sort of simple declarative sentences. Those are usually best. But a lot of times we'll get agreements that have got lots of sort of extra words, legalese in them. That's a style. It's not one that I recommend, but if that's the style of the agreement, I just continue drafting in that style. Some sort of technical things. Things like numbering, format, underlining, bolding, paragraph indentation. That should really all be consistent throughout the document. Don't use different sort of numbering styles or indentation conventions, because it throws the reader off. And if something is different, sometimes you say, why is it different? If there's not a reason for it to be different, it shouldn't be different. That's made a lot easier now with Word and its paragraph numbering and sort of stuff. You're going to almost get consistency automatically. But in terms of terminology, you want consistency too. It drives me crazy when I get an agreement from the other side that says XYZ Corp, paren, quote, seller, paren, quote. Okay, so the defined term is seller. And then throughout the agreement, sometimes they say seller, sometimes they say the seller. It's not technically, it's not going to get the agreement thrown out of court, but it's just, there's no reason to be inconsistent, so why be inconsistent? Another pet peeve, and it's sort of a lazy person's drafting. You'll see Bobo, Inc., a Virginia corporation, paren, quote, Bobo, quote, paren, quote, Bobo, or, quote, seller, quote, paren. So it's either Bobo or seller. So anytime you see seller, it means Bobo. Anytime you see Bobo, it means seller. That's, yeah.
I'm sorry, I didn't mean to interrupt. You had mentioned just a moment ago about the importance of prior art.
Yeah.
And I imagine in large firm contacts, you have really an extensive kind of database of prior art that you can rely on, and the firm is tested over time. To what extent, if ever, will you go outside the firm to search for sources of prior art? How does that affect your practice?
I personally don't do that very often, but for instance, people in M&A do it all the time. If you go online, and all of you probably have better skills at going online than I do, but if you go online and look up SEC filings, you'll find lots of merger agreements and buy-sell agreements, all that sort of stuff, all of which you'll usually see the law firm that drafted them. If it's some big fancy New York firm, chances are it's probably a pretty good agreement. And that's a great free source of stuff, is just look at SEC filings. You can also, hell, you can probably look up Wikipedia and look up asset purchase agreement. You'll find something. I'm not sure I would trust that as much as something that drafted. So anyway, if you're going to pick a defined term, use that defined term throughout. Don't confuse your writer. Another final nit on this. A lot of agreements you'll see start out buyer shall do this, seller shall do this, and then it becomes will, and then it becomes shall, and it's, God knows what. Stick with one sort of form of the verb. I'm a big believer in will. My favorite drafting trick is at the beginning of the agreement, after you do, this purchase agreement dated as of February 28th between buyer and seller, whatever. The parties agree as follows, colon, and then your agreement kind of flows from there. Buyer will purchase 16 widgets, seller will sell 16 widgets. And so all you need to do is will. It's usually in the future tense, these agreements, because it's something that's going to happen. And just stick with will. If seller doesn't sell the widgets or buyer doesn't buy the widgets, then it's a breach of the agreement. Pretty simple. You don't have to get into all the, if seller shall have purchased 16 widgets, then buyer shall, you get the idea. There we go. Drafting from scratch. As I said before, normal rules of good English, good grammar, what you learn in high school apply. Subject-verb agreement. It sounds kind of Mickey Mouse to say it, but a lot of times in agreements, you don't see it. Agreement of tenses, that's another one. Most agreements are drafted in the future tense. Sometimes they're statements in the present. Seller is a Virginia corporation. Seller has all licenses required for it to do business in the jurisdictions in which it does so. That's for sort of representations, but the promises to perform in the future are usually in the future and will suffices. Agreement of nouns and pronouns. Just really simple stuff, but A lot of times you see it in agreements, they don't do it. Again, the old favorite from Strunk and White, active voice. Seller will purchase the widgets rather than the widgets will be purchased by seller. You'd be amazed at how often how often you see the passive voice. The purchase price will be paid in 4 installments. How about buyer will pay the purchase price in 4 installments? It's just better. Brevity. Try to omit lots of needless words. And some people will disagree with me on this, but sometimes legally it's like payment therefore is, to my mind, is not so bad. Instead of payment for the goods, or that's not a very good example. But a lot of times there's shortcut words like therefore, therein, hereunder, rather than under this agreement, saying that every time as you draft it, it just gets to be a little irritating. The other thing about brevity is the fewer words you've got in an agreement, is the less words that you can be hanged with by the litigator. I would refer you to the elements of style, which I'm sure you all have. It is useful in contract drafting as well as writing both quick. Here's sort of a practical thing. If you're working in a firm or working for another lawyer, look at the style that your lawyer, that the person you're working for uses, and imitate it. A lot of people, me included, when you first get to law school, I'm a great writer, the guy that I'm working for really can't write, I'll show him how to write. That doesn't work so well. Just grin and bear it, imitate it. Proofread, proofread, proofread. Don't really need to say that too many times, or you can't say that too many times. And don't do it on the screen, unless you're really a lot better than I am. It's better to see it in writing, because that's how the clients frequently get it. This presentation, which I gave a couple years ago, I updated the front page of it, sent to Catherine Huban, and had it dated March 1st, 2012. And I realized that I proofread it on the screen. I didn't look at it before I printed it. So I had to call her and say, can you fix that? If you have the time, and it's a good idea to make the time, get somebody to proofread the document behind you. You probably got another associate in the office next door, or tell your assistant, whatever. Get somebody else to look at it, because if you've been sitting there drafting this thing, you've been thinking about the substance of it, not necessarily what it looks like, and a fresh set of eyes is always useful. And then finally, one of my favorite things that, again, the first partner I worked for said, spell check is not think check. Yes, it'll help you fix spelling mistakes, but you still need to proofread to make sure that you haven't left out words. I'm a terrible typist, so I leave out little words like the ofs, the tos, the a's. Really need to look at it. Here's some more personal favorites. Know how to use that and which. Again, elements of style stuff, but it's amazing how many lawyers don't know how to do it. You just see which everywhere. And my general rule in talking to new associates is 90% of the time it's going to be that. But then if you really want to give them a reason, it's the restrictive versus non-restrictive. The sentence can, if the sentence can do without it, it's probably going to be, if you can't do without it, it's probably going to be that. If it could, it's which. Gems that sparkle often elicit forgiveness. Diamonds, which are expensive, often elicit forgiveness. You get the idea. We've already talked a little bit about will versus shall. If you're going to use shall, realize that shall applies to, it's an obligation on a person or an entity. It's not an obligation on a date. It can apply to a person. The buyer shall, but the term of the agreement shall begin on January 1st. This is wrong. You can't. It's not. You can't put an obligation on an agreement. And then again, here's another one of those examples of where you shall sort of gets you into a do loop. In the event that shall or shall fail to give notice of termination, the agreement shall renew automatically. It's just too complicated. As I said before, will indicate something that's going to happen in the future, which is what your contract's going to do. Oh yeah, here's my all-time personal favorite. And/or. It's not English. It's not a word. It's also a lazy way. It's a lazy person's way of not figuring out what it is you really mean. Is it or? Is it and? They're different things. Seller will do A and B. That means seller's got to do A and B to get paid. Seller will do A or B. Means seller can do A or B. In most contexts, it means if they do A or B or both. Seller will not do A or B. That means they can't do either. Sorry about that. Usually this is on. Seller will not do A and B. That means seller can't do both. It can do one or the other, but it can't do both. One of the ways that people get around sort of their discomfort with the use of the word or is to have a provision in the front of the agreement on interpretation. So when you see or, it's disjunctive, but not necessarily exclusive. So that means if you do A or B, it means you do A or B or both. If you really mean A or B, but not both, then say A or B, but not both. Another word on sort of interpretive provisions. A lot of times in agreements you'll see ad nauseum, including without limitation, including but not limited to, that sort of thing. If you put up front the words include and includes means including without limitation or including but not limited to, then you don't have to say it all the time. You just say includes. I think that's a nice little shortcut. If you're doing an international agreement, a lot of times you put up something up front. The word dollar or the sign dollar means U.S. dollars, so you don't have to say U.S. dollars every time it comes up, which drives me insane. And the things which I've always found a little bit strange, words defined in the singular have the same meaning in the plural. I'm not sure I really agree with that. I mean, one cupcake versus two cupcakes is slightly different, but I guess the word cupcake has the same meaning. But you'll see that kind of provision. Oh, here's another and or. If the producer agrees with the cut and or clarity of a unit, it goes to step 15. So what does that mean exactly? You have to agree with just one, or you have to agree with both of them. It creates ambiguity. Producer does not agree with the cut and or clarity of a unit, it goes to step 18. Again, you have to disagree with one, or you have to disagree with both of them. I think what they meant in both of these instances was or. A few more sort of personal things. Draft in the singular. If you draft in the plural, just like the word shall, as you go down the line, you get into all these sort of weird questions. All drivers must obtain a license for their vehicle. All the drivers only have one vehicle. All drivers must obtain licenses for their vehicle. So does that mean they all have multiple vehicles, or they own vehicles together? Not sure. Better is each driver must obtain a license for such driver's, his or her vehicle. Must obtain a license for their vehicle, sort of gets you up into that first one, which is, do all the drivers own the same vehicle? Plain English drafting. This is something that I sort of come at with a sort of personal bias because I'm from a big firm. Most of the drafting I do is to be read by other lawyers, all of whom are reasonably schooled in the English language. But a lot of times, you're going to be drafting things for consumers. I do some work where I draft things that are crop purchase agreements for farmers. And the clients prefer that the drafting be in plain English so that somebody with a non-law school education can read it, which is great. But you have to be kind of careful about plain English drafting because as you dumb it down, you lose some shadings of meaning, or you can lose some shadings of meaning that you get when you use more legal language. Drafting in plain English is sort of hard. I would say that one thing that's useful is that sometimes you take an agreement that you've drafted for a lawyer, and you go back through it and strike words that aren't really necessary to the meaning of the provision. I think that's a good exercise. That's a little bit different from plain English drafting. I'm a little bit leery of plain English drafting, but one of the articles in your package by Wittick is a good article on plain English. Finally, in your package, I've given you some suggested reading. I don't know if you can see it, the first page in here is Working with Contracts. It's by a guy named Charles Fox, who's a partner at Skadden Arps in New York. And this is probably the best book I've ever seen on contract drafting. It's really geared to M&A context, merger agreement, purchase agreement. But it has all the different provisions that go in an agreement like that. And it sort of takes you through them from the introductory provisions and representations and warranties to covenants of the parties to conditions precedent to closing to all the sort of legal stuff at the end. It's just a really good primer on how to draft a good contract. Another book you'll see the first page of is Manual Style for Contract Drafting. That's a slightly less useful book, but it's still pretty good. And then any book or article by Brian Garner. I don't know if you guys have heard of him, but he, I forgot what his most famous publication is, but he's a guy from Texas. He's on sort of the lecture circuit. He's very entertaining, but he's a very good writer about legal writing. And anything that you see that he's written is really good. And then I also included two other things in there. One is just a little essay by a guy named George Gibson, who was a partner at Hunter Williams for 150 years, died sometime in the 80s, but he was a great lawyer and a really good writer, so I'd encourage you to read that. And then finally, gave you the article on Plain English for Lawyers by Richard Wittick, and you can sort of come to your own conclusion about whether you like plain English drafting. As I say, I come at it with a little bit of a personal preference against it, but I can be persuaded. That's all I've got. Does anybody have any questions? I mean, you guys, I'm a little bit leery of, yeah.
In drafting a document, the language by itself would be very limited. Do you recommend or do you normally add a section of definition for certain terms like why to make sure that the party understands what they're talking?
Absolutely. That's usually the first section of an agreement is to define terms. And you can either try to define them all up in the front section, or you can define it as you go along and reference that definition in the body up in the front section. I think that's a good exercise to make all the definitions you've got in the agreement in that front definition section, either with its substance or with a cross-reference, so that you know anytime you're reading through the agreement where to go to find out what a term means. That's a great question. Anybody else run into anything in your 6 months of practice that you got questions on?
Cool. Yeah, I learned this from actually a colleague and also a printer, that if you have 9 paragraphs on a page, he actually goes through and reads, when you talk about proofreading, he'll go back through and read the bottom paragraph first and then sort of work backwards on the document, because your eyes get lazy as you I know what's coming next, I know what's coming in the next sentence and the next paragraph. But if you actually take the individual sentences and read them backwards, you catch.
That's exactly right. I mean, that's great advice, and that you did hear it from a printer. They're the ones who always say that, which is read it from the bottom up. You do. That's how you catch the missing words. Anybody else? All right. Well, thank you very much. Go get coffee or lunch or whatever.